So, God bless. Proceed ko sa akong part, which is the grounds for judicial intervention in administrative activity. So, first, ato sang i-define what is judicial and what is administrative. So, judicial, it refers to the branch of government responsible for interpreting and applying the law through the court system. So, it involves judges, courts, and legal processes that resolve disputes and administer justice. So, judicial or hudikatura o panghukuman. So, ito ang sangay ng pamahalaan na responsable sa pagpapaliwanag at pagpapatupad ng batas sa pamamagitan ng sistema ng hukuman. So, administrative refers to the aspect of management and organization within an institution or government. So, it involves activities such as planning, coordinating, and overseeing the implementation of policies and procedures to achieve specific goals or objectives. So, meaning, administrative, ito ay tumutukoy sa mga gawain o aspeto ng pamamahala at organisasyon sa loob ng isang institusyon o pamahalaan. Karaniwang kasama rito ang pagpapaplano, koordinasyon at pagpapatupad ng mga patakaran at prosedur upang makamit ang mga layunin o adhikain. So, the main doctrinal foundation on which judicial review of administrative action is based is that of ultra vires. So, what is ultra vires? So, ultra vires, it is a Latin term meaning beyond the powers. In legal context, it refers to action taken by an entity that exceeds the powers or authority granted to it by law, its charter, or its governing documents. When an entity acts ultra vires, those actions are considered invalid or void. So, in the context of administrative law, if an administrative agency acts beyond its statutory authority or in a manner inconsistent with its enabling legislation, its actions may be deemed ultra vires. This can open the door to judicial intervention to correct or invalidate those actions. So, to understand this doctrine, we must clarify the various types of function which an agency may perform for the readiness of the courts to intervene depends, or so it appears from the cases on what kind of decision is being challenged. So, according to my research, there are 7 that agencies can perform various functions that can affect the readiness of courts to intervene. These functions can include: first is the regulatory functions. Agencies often have regulatory authority over specific industries or sectors, ensuring compliance with laws and regulations. Examples: EPA or Environmental Protection Agency in the United States regulates air and water pollution standards, ensuring compliance with environmental laws. So, if an agency effectively regulates an industry, courts may be less inclined to intervene, trusting the agency's expertise. Second, the adjudicatory functions. Some agencies have quasi-judicial powers to adjudicate disputes within their areas of jurisdiction. Courts may defer to agency decisions if they find the agency's process fair and its expertise relevant. Example, the NLRB or the National Labor Relations Board in the United States adjudicates disputes between employers and employees regarding labor practices and union activities. So the third one is the policy implementation. So agencies implement and administer policies established by legislative bodies. So if agencies effectively implement policies, courts may see less need for intervention. So example, the HHS or the Department of Health and Human Services. So in the United States, implements policies related to public health, including the Affordable Care Act or ACA, by overseeing programs such as care, and medic aid. So the fourth one is the investigatory functions. So agencies investigate alleged violations of laws or regulations So example, the Securities and Exchange Commission or SCE in the United States investigates alleged violations of securities laws such as insider trading or accounting fraud. So by that, if agencies conduct thorough investigations, courts may rely on their findings when making decisions. So the fifth one is the administrative functions. Agencies perform administrative tasks such as issuing permits, licenses, and approvals. So example, in the Department of Motor Vehicles or DMV, administers driver's licenses and vehicle registrations, ensuring compliance with state laws related to driving and vehicle ownership. By that, courts may defer to agency decisions in administrative matters unless there's evidence of arbitrary or capricious behavior. So, number 6, expertise and technical assistance. So, agencies often possess specialized expertise in complex technical or scientific matters. So, example, the Food and Drug Administration or FDA in the United States provides expertise in evaluating the safety and efficacy of pharmaceutical drugs and medical devices before they can be marketed to the public. So the courts may defer to agency expertise when dealing with technical issues beyond their competence. So the last one is the enforcement functions. So agencies enforce laws and regulations through various means, including fines, penalties, and sanctions. Such example is in the Federal Trade Commission or the FTC. In the United States, enforces consumer protection laws by taking action against companies engaged in unfair or deceptive practices such as false advertising or scams. So by that, effective enforcement by agencies can deter violations and reduce the need for court intervention. So overall, the readiness of courts to intervene may depend on how well agencies perform these functions, their perceived legitimacy, and the adequacy of their actions in addressing the issues within their purview. So however, it is extremely difficult to classify the case law into watertight compartments. But 3 general areas will be examined: judicial responses to attempts to oust their jurisdiction, disputes raising the caution of ultra vires, and cases in which the judges have considered the applicability or otherwise of the principles of natural justice. So, let's proceed. So, can the court's jurisdiction be excluded? So, statutory provisions may attempt to prevent from intervening in administrative action in a number of ways. So, it may be, for example, that the statute provides that the decision of an administrative agency shall be final or even shall not be questioned in any legal proceedings or whatsoever. So, may I repeat the question? So, can the court's jurisdiction be excluded? So, the answer is yes. The jurisdiction of courts can be excluded or limited in certain situations. So this can occur through various legal mechanisms, such as first is the arbitration agreements. So party may agree to resolve disputes through arbitration instead of litigation in court. So example, arbitration clauses are commonly included in contracts and can exclude or limit the jurisdiction of courts in specific matters. So example, a consumer signs a contract with a cell phone provider that includes a clause stating that any disputes between them must be resolved through arbitration rather than litigation in court. Number 2, so forum selection clauses. So contracts may include clauses specifying the jurisdiction or venue where disputes must be litigated. This can effectively exclude the jurisdiction of courts in other locations. So example, a multinational corporation includes a forum selection clause in its contracts with suppliers, specifying that any disputes must be litigated in the state of Delaware, effectively excluding the jurisdiction of courts in other locations. The third one is the tribunals and administrative agencies. Some disputes fall within the jurisdiction of specialized tribunals or administrative agencies, which may have exclusive authority to hear certain types of cases, thereby excluding the jurisdiction of regular courts. Example, a dispute over workplace discriminations is filed with the Equal Employment Opportunity Commission or the EEOC in the United States, which has exclusive authority to investigate and resolve such complaints before they can be brought to court. 4. Sovereign immunity. So governments and government entities may enjoy sovereign immunity from lawsuits in certain circumstances, effectively excluding the jurisdiction of courts over them unless specific conditions are met. So example, a foreign government is sued in a U.S. court for alleged human rights violations, but the court dismisses the case citing sovereign immunity, which exempts the foreign government from being sued in U.S. courts for certain actions. Number 5. So, statutory limitations. Laws and statutes may limit the jurisdiction of courts in particular matters or against certain parties, such as foreign sovereigns or military personnel. Example, a law in a particular state limits the ability of residents to sue the state government, consents to be sued under specific circumstances unlimited in the statute. So the last one is the consent. In some cases, parties may consent to exclude or limit the jurisdiction of courts through explicit agreements or actions, such as by waiving rights to challenge jurisdiction. So example, two parties involved in a business dispute voluntarily agree to submit their case to mediation, explicitly waiving their right to pursue litigation in court if they cannot reach a resolution through mediation. So all in all, while courts generally have broad jurisdiction to hear cases, these mechanisms allow parties to tailor the resolution of disputes according to their preferences and needs, potentially excluding or limiting the involvement of courts. Ultra vires unlimited judicial intervention. So as we have seen, the basic ground for judicial intervention in administrative activity is that the agency in question has exceeded or abused its powers. So the ultra vires doctrine is extremely wide in its ambit, covering both substantive ultra vires or where a specified procedure has not been complied with, such as a requirement to observe the rules of natural justice, considered in the next section. So once again, much depends on the way in which judges interpret both the administrative action and the statutory provisions which authorize that action. So, may I repeat, unlimited ultra vires is unlimited judicial intervention. So, it is unlimited judicial intervention. So, unlimited judicial intervention, it refers to the extent to which courts can review and potentially overturn actions taken by administrative agencies that are deemed ultra vires. So, in some legal systems, courts have broad powers of judicial review to ensure that administrative agencies stay within their prescribed powers and act lawfully. So this can involve striking down regulations, orders, or decisions made by agencies that exceed their authority. So the concept of ultra vires and the extent of judicial intervention vary depending on the legal system and the specific laws and regulations in place. In some jurisdictions, courts may have significant latitude to intervene and correct ultra vires actions by administrative agencies, while in others, the scope of judicial review may be more limited. Natural justice, the duty to act fairly. So, exactly, because natural justice refers to the principles of fairness and equity that guide legal and administrative proceedings. So, one of the key principles of natural justice is the duty to act fairly. So, which requires decision makers to conduct proceedings in a fair and unbiased manner. So, this duty encompasses several elements, including first is the notice. So parties should be given adequate notice of any proceedings or actions that may affect their rights or interests. So example, before a tenant's lease is terminated, the landlord must provide written notice stating the reasons for termination and the timeline for eviction, giving the tenant an opportunity to respond or rectify any issues. So maghatag og example sa notice, no. Kanang kabalami nga kanang among lugar dapit is kanang daplin og karsada, tapos kanang karsada dira ipadako na, tapos sakto ilang gibuhat nga before sila mo kon bitaw kanang moguba sa among balay dapit kay makuhaan man na maghatag silang notice. So sakto ilang gibuhat kanang makabalo bitaw may nga kana di nga mo dapit is makuhaan. So importante jud nga kanang before sila mo kuha sa among balay dapit, so hatagan mig notice. Number 2 is the opportunity to be heard. So parties should have the opportunity to present their case and respond to any allegations or evidence presented against them. So example, in a disciplinary hearing at a university, a student accused of academic misconduct, it is given the opportunity to present their version of events, call witnesses, and cross-examine evidence presented against them. So example, no, katong sa opportunity to be heard. So sa example nato akong gihatag, no, kay a student accused of academic misconduct. So is given the opportunity to present their version of events. So kanang before sila mo kuan kung tinuod ba na iyang kung sakto ba na ayang kung sayo ba na yang nabuhat, so dapat na sila'y kanang mag-call check witnesses, then cross-examine sa o kanang importante jud is ang evidence, kanang magpakita silang evidence nga kanang butanga is iyang gibuhat. So the third one is the impartial decision maker. Decision makers should be impartial and free from bias or conflicts of interest. So example, in a court case, the judge is expected to rescue themselves if they have a personal or financial interest in the outcome of the case, ensuring that the decision maker is impartial and biased. So sama sa akong gihatag nga example katong court case sa impartial decision maker. So sa usa ka kaso dili lang kay kausa kundi murag katuluman ata. So mas nindot nang ingon ana kay kanang nabitaw impartial, dili pa final nga kanang kasuha nga isampa saya is iyang gibuhat. So number 4, reason for decision. So decision makers should provide reasons for their decisions, allowing parties to understand the basis for the decision and assess its fairness. So example, after a zoning board denies a development's request for a building permit, they provide a written explanation detailing the factors considered and the legal basis for the decision, allowing the developer to understand why the request was denied. So sama sa akong gihatag nga example nga katong after a zoning board denies a developer's request for a building permit, so they provide a written explanation. So why nga kana is nag-request sila og building permit, kanang written explanation nga nagpasabot nga kana nga dili ni dayon bitaw because of some reasons of some reasons for decision. So, masabot mo pas masabtan pod sa usa ka kuan nga anong ang iyang request is gi-denied. Number 5, no arbitrary decisions. So decisions should be based on relevant evidence and legal principles rather than arbitrary or capricious considerations. Example, a government agency cannot deny an individual's application for a license without providing any reasons or explanations, as this would be considered an arbitrary decision lacking a rational basis. Instead, the agency must base its decision on relevant criteria outlined in the law or regulations. All in all, the duty to act fairly is fundamental to the rule of law and ensures that individuals are treated justly and equitably in legal and administrative proceedings. It helps safeguard against abuses of power and ensures that decisions are made in accordance with the principles of justice. So the conclusion regarding the grounds for judicial intervention in administrative activity often emphasizes the need for balance. While courts play a crucial role in ensuring legality and fairness, excessive intervention can undermine administrative efficiency. Thus, a nuanced approach that respects both legal principles and administrative expertise is essential. So that's all.